Good morning again. How's everyone doing? Good. My name is Kristen Kuran, and as you may have seen in your program, I am now the Executive Director of the Fair Housing Center. Thank you. I have the honor of welcoming you to the 12th Annual Fair Housing Breakfast event. Whether you're joining us in person or watching the live stream, thank you for being here this morning. This event would not be possible without the support of this year's sponsors: Fifth Third Bank, Washtenaw County Office of Community and Economic Development, Zingerman's Community of Businesses, and our bronze sponsors, Bank of Ann Arbor, Delta Dental, Federal Home Loan Bank of Indianapolis, Greater Metropolitan Association of Realtors, Lake Michigan Credit Union, Michigan Realtors, Old National Bank, Parta Credit Union, Reinhardt Realtors, University Bank, and Zillow. Thank you. I also want to acknowledge our individual sponsors, all of our members, and today's attendees. On behalf of our past, current, and future complainants, the board of directors, and our staff, thank you for your continued commitment to fair housing. We cannot do this work without you. Before we go any further, I want to take a moment to acknowledge the Fair Housing Center's founding executive director, Pam Kish. As you may know, Pam is retiring at the end of this month after more than 33 years of working to end housing discrimination across Southeast and Mid-Michigan. Pam, thank you for your steadfast principled leadership, mentorship, and friendship. I'm not going to cry right now. You have built the Fair Housing Center into a force for justice. Your legacy is not just in the cases we've won or the accessibilities granted, but in the people and communities that now have fair access to opportunity because you knew that we indeed can fight housing discrimination and win. Please join me in thanking Pam and welcoming her to the podium.
Thank you, Kristen, and all of you for being here. I'd like to introduce my friend, Mike Steinberg. He's going to talk about the recipient of our award recipient, Megan Morse, and her precedent-setting case. Mike is the founder and director of the Civil Rights Litigation Initiative at Michigan Law, and he and his students represented Megan Morse. He is the former legal director of the Michigan ACLU, a longtime Fair Housing Center cooperating attorney, and his storytelling has been featured on the Moth Radio Hour. Mike Steinberg.
I know this isn't Pam's retirement party, but I do have to say how much I'm going to miss her. The Southeast Michigan is going to miss her. She's been a civil rights leader and icon in this area for so long. And one good thing about a great leader is they have a great succession plan. And Pam has the best plan. Kristen and Nikki and the whole team are going to carry on her legacy. So I'm very excited about what's in the future for the Fair Housing Center. 3 years ago, Pam called me and said, we have a major problem in Ann Arbor, a major fair housing problem. And she said that there is an ordinance in Ann Arbor that prohibits discrimination based on source of income, and it specifically says that landlords cannot fail to consider housing vouchers as income when deciding whether to accept a tenant. And I said, well, is there a private cause of action? And she said, yes, there is. And I said, well, that's great. It sounds exactly like the cutting edge case that my students and I work on. And I said, who's the plaintiff? And she said, well, we've had lots and lots of complaints about this, but nobody's willing to step up. A lot of them were in vulnerable situations, and it's a lot to get involved in litigation. So I said, I bet my students can find the perfect plaintiff. And they did. They talked to a lot of fair housing groups, a lot of housing organizations, and Megan Morse stepped forward. And she was the perfect plaintiff. She's from Ann Arbor. Originally, she wanted to move back. Her child lived here. She continued to receive treatment at Michigan Hospital for epilepsy, and she had a housing voucher so she could afford it, but she kept being denied over and over again. And so we filed a lawsuit on her behalf, the first of its kind under the Ann Arbor Ordinance, and we won. Last spring, the judge signed an order that the parties agreed to that said the apartment complex had to consider vouchers. It required the housing complex to do training, and it required the housing complex to change its application to make it specific that housing vouchers would be accepted. We also settled for compensatory damages and attorney's fees, which is confidential. But it was a great victory, not only for Megan, for all people with housing vouchers in Ann Arbor, and for the city of Ann Arbor, who seeks to make it more accessible to people who are low income and people with disabilities. Also, because during the litigation there was an amendment to the Michigan Civil Rights Law, this could have statewide impact. The Elliott-Larsen Act was amended to include protections based on source of income, and so we expect this case to have an effect statewide. Megan was not only the perfect person, she's the perfect plaintiff, she's a perfect person. We had over 10 students working with her over the past 3 years, and they would all, without exception, come back to me and say, we love Megan. She never complained when she had to produce documents for discovery. She never complained when we told her she had to have her deposition taken. In fact, she was eager to have her deposition taken. And I think the love the students showed to Megan was mutual, because Megan decided, because of this case, that she wanted to become a civil rights lawyer. And she's back in school, acing her classes. She's about to transfer, we hope, from Washtenaw to the University of Michigan, and hopefully one day she'll be in my class. I think it's super appropriate that Megan received the Mark Mitshkun Award for many reasons, but one reason is that Mark, for a while, was a clinical law professor. And this case was brought by the clinic, and all the heavy lifting was done by clinical law students, including Alex, who is here. Would the board please come up here and help me present the award to Megan Morse?
Gotta put on my glasses. It's my privilege and honor to present this award to you, Megan. Mark would be happy to know you. The Fair Housing Center of Southeast and Mid-Michigan is presenting the Mark Mitshkun Board of Directors Award to Megan Morse for her precedent-setting fair housing case, Morse versus Wilson White, opening the doors for others denied housing based on their source of income. Congratulations.
I would just like to thank Mike and all the students that I worked with to help me through this. This is not just for me, but this is for everybody who has a disability and requires the fair housing to be able to live in Ann Arbor.
Good morning. My name is Ann Rout, and I am the chair of the board of the Fair Housing Center. And I absolutely want to add my note of congratulations to our award winner and to thank Mike and the students for their work on behalf of Ms. Morse. Having worked with clients for decades, I know it takes a strong person to be willing to have their case carried forward. So thank you very much for doing this. But I'll just add, this is one of the many cases that the Fair Housing Center has helped identified, investigated, and supported over the many years of its existence. But this advocacy work, including the investigation, the testing, the education, and the outreach work of the Fair Housing Center requires trained staff. It requires supported volunteers. It requires resources to provide for the outreach and education across the 9 counties that we serve. And while the Fair Housing Center is largely supported by grants, revenue from events like this one and donations are essential to maintaining the foundation of this organization. So that is why I am up here now. We set a goal of raising $55,000 with this event, and last I checked with Kristen, we were at $49,700. We're very, very close. So if folks have the capacity to consider making a donation today, it would be great if we could meet that threshold. But I'll just add that support for this organization is particularly critical at this time in our world, in our communities here. We don't have the same certainty of our ongoing federal funding as we've had in past years. And this work becomes even more critical with some of our rights being taken away. So please consider making a donation or at least becoming a member of the Fair Housing Center. An individual can support the organization and become a member for as little as $35. And we all know there is strength in numbers. So please, if you haven't joined this movement, please do so today. And then my last point about this fundraising pitch is that what a nice gesture it would be to make a donation in honor of our founder and outgoing executive director, Pam Kish, who I have worked with her from the beginning. And I can tell you, Pam has seen the financials of this organization go like this. She has always stood firm. She has never, ever strayed from the mission of the organization. She has taken pay cuts, time off, always kept this organization. And so look at the foundation she has now. Look at the support she has built in this community. And we want to make sure that that continues as we go forward. So if you aren't able to make a donation, at least please consider becoming a member of the organization. Kristen, is there a QR code on the back of the program? So there's a QR code for those of you who are technologically sophisticated. I was able to do it last year. And you can find your way and quickly make a donation. We like to make it easy. But certainly later on, become a member of the organization. It's just a way of moving us all forward. So now I get to say thank you to Pam again and ask her to come up to the podium.
Okay. It is really nice to see all of you here. I think this is one of the biggest breakfasts that we've had. And it's a nice way for me to go out. And I also want to just acknowledge that the Fair Housing Center is going to be in wonderful hands. Kristen's been with the organization for 20 years. She's had every job at the Fair Housing Center except executive. Well, now she's executive director. So she has a lot of depth of knowledge, and again, I think the board supports her, and I think things were going to go smoothly forward. I also want to acknowledge Ann Rout and Michael Apple, who have been on the board of directors since we opened in 1992. So, Ann and Michael. Okay. So, many of you know his name from Michigan Public Radio. Lester Graham reported on environmental issues, public policy, politics, and issues regarding race and gender inequity. He recently retired from Michigan Public and generously offered to facilitate a conversation with our guest author of Containment, Michelle Adams.
Well, while you're doing that, I'm going to tell everybody who you are.
That sounds like a good idea.
So our guest today is Michelle Adams, as mentioned. She's the Henry M. Butzel Professor of Law at the University of Michigan. Professor Adams researches race discrimination, affirmative action, school desegregation, and housing law. She's been widely published in law reviews, magazines, and other media, including The New Yorker. And she was an expert commentator on Netflix series Amend, The Fight for America, and the Showtime series Deadlock, How America Shaped the Court. Today, we'll be discussing her book, Containment, Detroit, the Supreme Court, and the Battle for Racial Justice in the North. I love this. It brought a lot of context to some issues I knew a little bit about, but it was just an amazing story. And I guess as a lawyer, any lawyer would be really interested in this. But as a person who's just interested in equity, this was an amazing book. You really brought the people alive that are big players in this. So let's start with what the book is about. It's about the Bradley versus Milligan case, about desegregating Detroit metro schools. But I think we probably should first explain a previous case, and that is Brown versus the Board of Education.
Okay.
Could you talk about that?
Absolutely. But before I do, I want to say two things. Number one, thank you so much for inviting me here. I so appreciate it. And I appreciate you spending a little bit of time to chat about the book. But more importantly, I want to thank you, each and every person in this room, for all the work that you do with the Fair Housing Center. This is so incredibly important, and it connects to many of the things that I talk about in my book. But I just want to say that the work that everyone does here is tremendously important, and I thank you for that. Now, let's talk about Brown. What do you want to know, Lester?
Well, this is something that was passed quite a while ago. A guy named Thurgood Marshall was involved in this case. What was it about?
Okay. So come back with me, if you will, to 1954, Brown versus Board of Education. All right? This is a case that we all know on some level. And of course, this is the case where the Supreme Court said that it violated the Equal Protection Clause of the United States Constitution to separate students in school on the basis of race. This is a huge watershed case in our history, in our political history, our social history, our legal history. And it's really an important moment. It effectively overturns the Plessy versus Ferguson case, which had said that separate but equal was consistent with the Constitution. That's Brown, but I think part of what we need to talk about is the idea that although Brown is clear in saying that that's illegal, right? And we think about Brown and we think about Jim Crow and we think about the South when we think about Brown. Brown was written in a way that was somewhat ambiguous. That is to say, it's not 100% clear exactly what or how to interpret the scope of what Brown versus Board of Education meant. And in particular, because all of the states that were involved in Brown were southern and border states, one question became, well, does Brown just apply in the South, or does it apply in the North as well?
Exactly. And so there was no question, because there were state laws that basically demanded segregated schools. the North didn't have that in particular, but there were still segregated schools, and that made it a little bit more difficult and tricky for somebody to challenge
tricky.
it. I want to talk about the uprisings, the riots in 1967, the disruptions. President Lyndon Johnson assembled a commission to look at the cause of those, disturbances, the Kerner Commission, and that report concluded our nation is moving toward two societies, one black, one white, separate and unequal. And that describes exactly what was happening in Detroit with the schools. So with that in mind, what was the state of segregation in schools and the rest of the metropolitan area?
Yeah, so we sort of started out sort of setting the table and talking about Brown and thinking about that as our background case, and now we're moving over to talking about what's going on in the North and happening in Detroit, right? We had the uprising in 1967. And the question really is, well, what is the state of education in the Detroit public schools? And effectively, we have a separate and unequal school system in Detroit, right? There's no law that requires the students to be segregated. There's no city ordinance that does that. But notwithstanding that, the students are still segregated, right? And the question really becomes sort of like, what are we going to do about that? And in particular, if we're going to get into sort of what happened with respect to the case that got up to the Supreme Court, which is what my book is about, there's really sort of these different approaches to thinking about how to deal with separate and unequal schools, right?
So there was this idea that this was a natural thing. It just happened, Black people lived where they lived, and white people decided they wanted to live over here, and so it was just a natural thing. It just was the fact of life, right? But underlying that was government decisions and government regulations and redlining and all of these other things that are going out that made it impossible for many black families to move into these nicer places, or they just didn't have the money. So we still had segregation in a really way. Explain containment, because that's the title of your book.
So when we think about what's going on in the Detroit public schools, there's a couple different things happening. One is that the school authorities are actively perpetuating segregation, and there are ways that they do that. They might decide if they're able to build a new school, we're going to build the school directly in the center of a black neighborhood or directly in the center of a white neighborhood, and that school would be basically for that race alone. Or they might say, if you're going to a particular junior high, we're going to have particular feeder patterns, and you're going to feed into a particular high school, and that means that you're going to go to the high school for your race. Or they might have different kinds of student assignment policies, right? So there are all these things that are happening in terms of the school board and the school officials making these decisions, right? But it's not just that. What you're mentioning as well has to do with housing. And I know that's of great interest to you all here today, which is that it's not just that the school authorities are making school-based decisions that are leading to the schools being segregated. It's that they are saying, well, we're going to have neighborhood schools, right? And everybody wants neighborhood schools. It's not a problem. That doesn't violate the Constitution. But what the school authorities knew was that the neighborhoods themselves weren't just people they happened to want to live together. That is to say that there was deep-seated housing segregation that was related to government policy that created residential segregation. And then on top of that, the school authorities were using a neighborhood school rule, and they're basically incorporating the underlying housing segregation into the schools. And that's really what the book is about, and that's what starts the litigation going, right? Do we want to, before we get to the containment, you want to keep going?
Well, I was just going to say, we've talked about the lawsuit. It's called Bradley versus Milliken. So who was Bradley? And for those of us who don't know, who was Milliken?
Milliken was our governor, and so we know that. Verda Bradley was a black parent in the Detroit public school system. And one of the things that she noticed when she was looking at her neighborhood elementary school with Clinton Elementary was that it seemed like as the school had a greater proportion of African American students, the services and facilities were deteriorating. And her son was not getting the same kinds of educational opportunities that white students got in Detroit, right? And so she ends up meeting with the NAACP, and she becomes the lead plaintiff in this case, Bradley versus Milliken. But we should probably say a little bit about what's happening on the Board of Education as well.
Right, exactly. Because, there's a liberal group board members, majority of the board members on the Board of Education are liberal, and they're looking at this problem and trying to figure it out, and they're not coming up with very good solutions. And so explain how that was going on.
So this is an interesting moment, the late 1960s, early 1970s in Detroit and elsewhere, where you had a series of members of the Detroit School Board who had been not as concerned as we would like them to be about segregation in the schools. And then after 1955, Detroit gets its first black board member, which is Remus Robinson. And the school board itself begins to become more liberal. And just at this time in the late 1960s, early 1970s, the Detroit School Board is turned over and is now led by liberals who actually really care about what's going on in the Detroit school system, right? But they've inherited a system that is separate and unequal. And so one of the things that these members of the Detroit School Board want to do is to try to actually begin to deal with that problem. And one of the ways they want to deal with it is through instituting a limited integration plan, right?
Yeah, but they are limited by the boundaries of the school district, right? They're having a hard time going beyond that because that's their governance.
Well, that's true, right? So we think about Detroit, right? The Detroit school system, the Detroit school district is quite a large district. But just in terms of what they're trying to do, they're operating within that district. That's where their jurisdiction is, right? They don't have jurisdiction over the Southfield schools or the Royal Oak schools or the Oak Park schools. But we focus just on the school board in Detroit. They decide effectively in 1970 that for the first time ever, and this is voluntarily, not in response to some sort of court mandate or anything like that they're going to have a limited integration plan in the city's high schools, affecting about half of the city's high schools. And for the first time ever, white students are going to go to black schools and vice versa, right? And this is the integration plan that the board basically votes on. Now, I go into great detail in the book about sort of some of the political machinations behind that, and I think the board was incredibly well intended, but they maybe didn't sufficiently prepare the public for this, and the reaction to it was furious. There's immediate response from many white parents who are saying, no, this is not going to happen, right? And ultimately, the state of Michigan passes a law that basically says to the Detroit Board of Education, yeah, you had an integration plan, but sorry, you can't do it, right? The state passes a law that gets rid of the integration plan. And that's when the NAACP gets involved, right? And that's sort of the same time that Bradley is going to talk to the Detroit branch of the NAACP, because the NAACP says, well, wait a minute, this feels kind of Southern, right? We had an integration plan, but then we have a state law that says that you can't have it. That feels like, that in effect is a law mandating segregation. And that feels like a Brown versus Board of Education violation, right? And this goes back to what we talked about in the beginning about sort of what is the scope of Brown. Because if the scope of Brown is just in the South and just the border states, and just in states and jurisdictions that had laws that mandated segregation, well, maybe Brown doesn't really apply in the North. Maybe Brown doesn't really apply in the West. But the NAACP says, well, yes, it does. It's a nationwide rule. And the fact that the state passed this law to get rid of the integration plan, that violates Brown versus Board of Education.
I want to talk about a couple of the characters in the NAACP, Louis Lucas and Nathaniel Jones. Who were they and what were their roles?
So Nathaniel Jones ultimately becomes a judge on the Sixth Circuit Court of Appeals, which is the federal court right below the Supreme Court. He's the general counsel for the NAACP at the time. And so he's the one who's making all the decisions about how much money are we going to allocate to this case? Are we going to take the case or not? Ultimately, he's got to sign off on all the legal theories, and he's the one who's sort of at the top of the pyramid saying, this is what we want to commit to doing as the NAACP. Lou Lucas is the one who's sort of running the litigation, right? And he's an incredibly talented civil rights lawyer, and he rolls up to Nate Jones.
So Bradley case is filed in federal court in front of Judge Stephen Roth. Tell us about him.
I will. But again, just to make sure we're all together, remember, the state of Michigan passes that law. Law says you can't have your integration plan. That's the thing that starts the lawsuit, right? That's the initiating piece. And so we go and we file our case in federal court. We say there's a Brown violation. You get this wheel. You don't know what judge you're going to get, and they end up getting Judge Stephen Roth. This is really interesting. Judge Roth is a conservative. He's a part of the conservative portion of the Democratic Party, a Kennedy appointee. He's going to be the trial judge in this case. And when the case is first filed and it comes to him, he's like, wait a minute, what are you talking about? There's no Brown violation. This is Detroit, right? Brown doesn't really apply here. Get out of my courtroom. I think this is a bad case. He's really, really, really skeptical of the case, right? And so his initial reaction to the case is, this is a waste of time, it's frivolous, and we ought to dismiss it. But he changes.
Right, and part of the thing is really unique. The NAACP put up 4 big maps looking where just how desegregation looked in the 1940s, the 50s, the 60s, and 70s. And that really had a great influence on the judge. Why?
Yeah, so Lester asked me a couple minutes ago, what's the containment? And this is a long this is a long wind up to getting to explaining to you what the containment is and why the book is called that. But again, so we filed this case. We were just worried about that law that got rid of the integration plan. But the case quickly becomes broader than that. And Nate Jones is really one of the ones who says, well, you know, while we're here and while we're at it, we aren't just going to challenge the state law that said no integration plan. Actually, the school district's been running a separate and unequal school system for years and years and years, for generations, and we need to put all of that evidence in front of the court. So really what happens in the case is not just this little case about that state law, it's about how northern school districts actually prosecuted and maintained segregation in their school systems, right? And so the case gets big, and the thing you need to understand about this, so now we've got our heads in, we're thinking about the case in Detroit, we're thinking about Brown took place in terms of dealing with the South. Well, what's the job for the lawyers? The job for the lawyers is to say, okay, there's a Brown violation in the North. There had been some lower court cases that, you know, before the Detroit case. And one of the things that the lawyers learned, and this is Lou Lucas and this is Nate Jones, is that in similar situations, when northern school districts were sued, the defendants would say, well, it's not us. It's not us. You know, it's just neighborhood schools. Now, we don't know why the neighborhoods are segregated. And even if we knew why, and even if they were segregated, it's got nothing to do with us because we're the school authorities, right? So effectively what they would say is you can't hold us on that. You can't charge us with that. We're not responsible for that. And so one of the things that happens, and I think what's of particular interest for the folks in this room, is that the lawyers realize that they can't just have a case that talks about the things I told you about a couple minutes ago. What were your feeder patterns? What were your school assignment patterns? Where did you actually build the high school? They had to have a bigger case. And the case that they needed to try was not just what were the school authorities doing, but they needed to talk about housing. And so what they did was they put on a case that was 41 days, 10 days of which dealt solely with housing in southeastern Michigan, right? And dealt solely with segregation in housing in southeastern Michigan, right? Again, school case, we had the law, we broadened out the case, but we know what happened in some of the other jurisdictions, and we need to sort of take the defendant's defense away of, well, we just didn't know about it, or there's no government policy, or we're just, you know, giving the parents what they want, and it's all racially neutral. We want to take that away from them. So this is a long response to what's the containment, right? The containment was the fact that African Americans in the city of Detroit couldn't live where they wanted to live, right? And what Lester's talking about are these 4 maps. The maps are census data. You all know that we do a census every 10 years. So we had 1940 census data, 1950 census data, 1960, and then fresh 1970 census data. And we've got these huge maps that are blown up, and they're right over the judge's sort of sight line. And he's looking at these maps, and when you put the overlays down, you see in 1940, black folks are clumped in sort of center city Detroit, and then in 1950 a little bit broader, 1960 a little bit broader, and then by 1970 folks have gotten almost up to 8 Mile, right? And so the judge, who of course had been really hostile to this whole case and thought that people were just living where they wanted to live, started to think, well, maybe people aren't just living where they want to live. Maybe they can't live where they want to live. And maybe that's got something to do with why the schools are so segregated. The containment was containing black folks in certain neighborhoods and not letting them out, and then black folks break out and break out and break out again.
So the idea became okay, well, this is a regional problem. This isn't just a Detroit problem. We've got this whole scope of things. A lot of the folks who lived in Detroit went into these counties, but they were all white. Now, the black people could make that move because of these housing issues, these housing regulations. So it became more than just a Detroit school district story.
Well, it's interesting, right? So, litigation, lawyers are very specific and they're very focused on what it is they have to prove. And we talk about the idea of proving constitutional liability, right? So what do you need to put in front of a judge so the judge will say, aha, there's been a violation of the Equal Protection Clause. Aha, there's been a violation of Brown versus Board of Education. So the four corners of the case are proving that there was unconstitutional discrimination, race discrimination in the city of Detroit. But once the housing evidence comes in, and we can talk about the kinds of evidence that come in, it's, the judge is hearing information that goes beyond the borders of Detroit. As you all know, the housing market isn't just contained to, no pun intended, to the city of Detroit. We've got regional housing markets, right? And so a bunch of the information the judge got during the course of the trial was that, black folks who wanted to live in the suburbs, or who might have wanted to live in the suburbs, including my parents, right, couldn't do that. It was just basically, this is 1970, it's basically impossible to get information about listings in the suburbs, and even if you do, then there's a whole lot of other reasons why it's impossible to live there.
And the real estate agents basically said, this is the way we've always done it. We know that we're going to steer black folks away from this neighborhood, even if they can afford this house, because that's the way it is.
Yeah.
But that started to change once they started bringing people in and saying, hey, why are you doing this in the court?
Let's talk a little bit about the housing evidence, and just in terms of the real estate piece, because I know that that's of great interest here. One of the things I didn't know before I started researching this book is that we had two racially separate real estate associations in the Detroit area up through the time that this case was tried in 1970, right? So black real estate agents were brokers. They were real estate brokers, and they belonged to the Real Estate Brokers Association. And then the white real estate salespersons belonged to the Realtors Association, right? And the reason why this really mattered, I'm sure you guys understand this, is that you can't get the listings. This is before Zillow. This is before the internet, right? If you want to be able to show prospective clients houses, you can't show them houses you don't know about, right? And so if you can't get the listings, you can't do that. And so there's just these racially separate brokers associations. That information comes into the judge. What else comes in? The history of racially restrictive covenants, which of course you all know a great deal about. But one of the, and we also know about Shelley versus Kramer. You guys know that the Supreme Court struck those down in 1948. But what comes in, the evidence that comes in that's the local evidence, is that we had a local title company that was continuing to report these restrictive covenants in the title, the title searches way past 1948. We had information about the federal government and the federal government's involvement in residential segregation in Detroit. Both with FHA policies, with the Homeowners Loan Corporation, redlining. We obviously have as you all well know, but many folks don't, that there's a segregation wall in Detroit. All of that information came in, and it's coming into a school case. All of that, what you would imagine would come in a housing discrimination case, it's coming into the school case. And a lot of the information that's coming in is going beyond the boundaries of the city of Detroit.
And when she says a wall, there was a physical wall at 8 Mile. Literally just keep...
Well, I'm assuming that this group knows that.
Yeah.
Right? Yes. Raise your hand. You guys know this, right? Yeah. Of course. But you know what? That's very specialized knowledge. That's expert knowledge. That's inside baseball knowledge, right? One of the reasons I wrote this book is to take it out of this room, right? I didn't know that. I grew up 1.5 miles away. And as I've gone around the country and talked about this book, people who've read it, particularly that wall, they're shocked. They just can't believe it. And I go to the wall, I talk about the wall at the end of the book, and they just have no idea. This is kind of a digression from our conversation. But the number one thing I hear from people when I talk about this book around the country is, I just never knew. I just never knew. And the reason I wrote the book was to try to change that. But again, it's great that we know this, but I wanted to take the information that we have and be able to pivot and provide it to a general interest audience.
Just as an aside,
Yeah.
walls haven't disappeared. Grosse Pointe had some barriers to
Yeah.
between the Morningside neighborhood and Grosse Pointe, so that's still going on.
Yeah, but that particular one was of interest to me just because it was basically within walking distance of my house and I didn't know it.
So back to Judge Roth.
Sure.
His thinking began to evolve as the case went on. What remedy was he beginning to consider?
Well, let's talk about that. So again, when we think about this, you have effectively two pieces of a big public litigation. You have the liability phase where you're trying to prove that there's been a violation of the Constitution, and then you have, well, once you've proven there's a violation of the Constitution, what's the remedy for the constitutional violation, right? The lawyers, Nate Jones and Lou Lucas and all the rest, they're focused on liability, right? Why are they focused on liability? Because they don't know how far Brown extends, right? That's what we started the whole conversation with. Does Brown apply? How do we prove that Brown applies? What are the defendants going to say? They're going to say it was all housing. We're not responsible. They're obsessed with proving their constitutional liability because unless they do that, we don't get to the remedy, right? So then the question becomes remedy, and it really comes in an interesting way because, I think we're on day 6 or 7 of the trial, and we have what's called interveners into the trial. So we have folks who think that the case is going to affect them and that the people within the case are not going to protect their interests. So there's a way that they can intervene in federal litigation. Who intervenes? The Citizens Committee for Better Education. Who are the interveners? They're white Detroiters who live in the northern portion of Detroit. And they're concerned that they're going to be required to participate in a school desegregation plan. And they don't want that. They want neighborhood schools. So effectively, they've intervened into this case to protect neighborhood schools and to make sure that the schools are all white, effectively. But what's so interesting about this question of remedy is that this whole notion of whether the remedy has to go beyond Detroit first comes into the case from the white interveners council, a guy named Alexander Ricci. And he starts sensing, like on day 6 of a 41-day case, I don't know, maybe we're going to lose this one, right? And if, in fact, the liability goes against the government, goes against the school authorities, what will the remedy be? And I think the initial thought is we don't want a Detroit-only desegregation plan. That's going to hurt my clients because they're the ones who are going to have to participate in it. And if, in fact, the overlapping system of segregation that's governmentally imposed and endorsed didn't stop at the 8-mile line. It goes beyond that. So any remedy that would include any remedy that the court is going to be able to think about should include not just the folks in Detroit, but folks in southeastern Michigan more generally, and that means the suburban school districts. That idea first comes into the case, not from the plaintiffs, not from the NAACP, but it comes from the Citizens Commission on Better Education.
Now, we're skipping a lot of stuff here, right? Because it's really
We're doing
complex.
okay.
But so this argument evolves into you can't desegregate without suburban schools participating. Suddenly, having African-American children in white schools and white kids in black schools turns into a real backlash about busing. And I find that such an interesting thing because we're talking about desegregating the schools, and it all came down to busing. And even the media latched onto this is a busing issue. How did that happen?
Because we're in a moment of political change, and the way that we think about these issues is changing right at that moment. So, right in sort of 1970, 71, 72, prior to that, the question was, how do we deal with an ongoing and incredibly serious constitutional violation? Right? The focus is on black children who've been deprived of equal educational opportunity. And at some point right in the very beginning of the 1970s, that stops being the issue. And what starts being the issue is what's the impact on white families? And the way that that is talked about is through the lens of busing, right? That's the way to get away from having to say we don't want to have black students in our schools. It's the government's forcing us to do something that we don't want to do, and most importantly, we're not responsible for, right? So busing, I think it's a really important sort of turn of and not to get too much into the present moment, but the reframe is really important. Right, we had the constitutional violation frame, and then suddenly it became the busing frame, and that shift between those two things is incredibly meaningful, and it basically shifts the defaults.
And this gets bad almost immediately. The Ku Klux Klan blows up 10 school buses.
That's in Pontiac.
Point. Yeah, right, in Pontiac. Then a group called, and this is also National Action Group.
Pontiac.
And so this is also causing an influence on what's happening in the case in Detroit, though, right? I mean, you can't really separate them because it's the same issue. White folks don't want this change. Even some black folks don't want this change.
Oh, yeah, that's right.
And so eventually, Judge Roth calls for a plan, though, to be devised for how Detroit schools and suburban schools could begin to integrate. So how did that go?
So Judge Roth says state and local school officials violated the Constitution. We've got a Brown violation. Liability. Important thing to note, that never changed. We go to the Supreme Court. The Supreme Court never challenged that. There's a constitutional violation, and that constitutional violation has withstood the test of time, right? The question becomes, what is the appropriate remedy, right? And this goes back to the trial now, and it goes back to the maps, because I think what Judge Roth started thinking was, well, why do we have to just think about this remedy within the city of Detroit? If we have evidence in the case that sort of goes beyond Detroit, and most importantly, if we have state education officials and state officials who violated the Constitution, and if under Michigan law, you can combine school districts at will, the state can, you can take them apart at will, the state can, then there's no reason why we have to think about the remedy as existing solely within the city of Detroit. More importantly, the court understood, the judge understood who he was, which is, he said he was really worried about the idea that if I issue a Detroit-only desegregation remedy, that is going to create an incentive. White folks are already leaving the city, but it's going to create a further incentive for them to leave, because what they're going to effectively be told is, all you've got to do is leave Detroit, and then you can just avoid desegregation entirely. So he was concerned about his court order, which is a form of state action as well, actually increasing the incentive to actually leave the city at this moment when that is a huge issue. He doesn't want to do that. He actually wants to try to stem the tide and try to figure out a way to knit together the city and the suburbs. And so
keep in mind, a lot of white people were already leaving
oh,
because
absolutely.
of 67.
67, but and there's more issues than that, right? I mean,
housing shortage.
Detroit hits its
else.
population maximum in 1950, and then it starts to decline after that. And a lot of it has to do with the economy and sort of where the jobs are moving, and et cetera, et cetera. Race is a big part of that too, but it's not solely about race.
Right.
But the judge, I think, is saying, I've got the defendants in the dock. They're the ones who can control the schools. I have evidence in the case that went beyond Detroit, and what I'm going to do is we're going to have real desegregation. And he's reading the cases, and the Supreme Court's saying, what do we need to have? We need to have meaningful desegregation, right? Not desegregation theater. And to have a meaningful desegregation means that we're going to bring in not just the city of Detroit, but roughly 50 school districts, right? So it's Detroit and Southfield and Royal Oak. And Ferndale and Birmingham, Warren, and many, many, many others, right, are all going to be in this one remedy. And it's going to affect about 800,000 students. If Judge Roth's remedy had held, it would have been the single largest metropolitan school desegregation remedy in the history of the United States. That's what's at issue in the containment.
So explain some legal things to me. So
Sure.
The judge sets up this commission to look into this, come up with a plan. In the meantime, it gets appealed before he makes a decision to the Sixth Circuit. How does that happen? Why does that happen?
The defendants have the right to appeal. They appeal, and of course, they get what's called a stay. And in effect, when they get the stay, the judge can't really do anything anymore, right? Although the one thing that could happen was the judge put together a group of folks to sort of begin to look at what a metropolitan plan would look at. And they did issue a preliminary report, which I meant to bring, and I left it at home. It came out in July of 1972, and it is absolutely extraordinary reading. The case has stayed. We go up on appeal a couple times to the Sixth Circuit, which we mentioned before, which is right below the Supreme Court. But this group puts together a document about sort of the idea of what this might have looked like. And it's just really, and it's in 72, it's really interesting reading from this vantage point. So the burden of desegregation was going to be equally shared between white kids and black kids. Black teachers would not routinely be fired as they were in the South when we transitioned from a dual to a unitary school system. And in fact, black teachers would have opportunities to teach in suburban schools where there were very few black teachers, if any. There'd be a minimum number of black teachers in these schools. We would minimize tracking. We would also minimize transportation times. A lot of the concerns that people had about desegregation, at least they're beginning to try to address initially in this document. It's just an extraordinary document.
One tiny point that I really found fascinating is that there had been busing going on already. Black kids that lived near white neighborhoods were being bused farther away to a different school that was a black school. So this is not unique. This is just didn't work for everybody. It only affected.
Yeah, I mean the thing the change in the nomenclature between constitutional violation and busing is also really difficult because busing is a way of transporting children to school, right? But it also took on the busing took on a life of its own in terms of what people actually associated it with.
So this actually went before the Sixth Circuit twice. Well, a panel of judges, three judge panel, and then the whole thing. The whole thing. And then it was headed to the Supreme Court.
But just to make sure we're together, the remedy portion that I just told you about, this broad remedy, gets upheld twice at the Sixth Circuit Court of Appeals. First with a panel, which is 3-judge panel, and then it's called en banc. And en banc is the whole Sixth Circuit. And it gets upheld twice, right? So, the NAACP lawyers are thinking, it was worth it to spend almost $1 million in today's dollars to litigate this case because we're rolling,
Yep.
right? We're kicking.
We're there. But there's something going on with the Supreme Court in the meantime. New judges, the Chief Justice retires, the Nixon administration.
Well, we have an election.
Yeah.
And that's, I think, the thing to keep in mind. We have the election of 1968 and then the election of 1972. But the election of 68 is incredibly important because Nixon wins narrowly. And then has an opportunity to appoint 4 Supreme Court justices, which changes the court dramatically, and reverberations of which we still feel today. But the court stops being the Warren Court, which was the single most liberal court in the history of the United States, and becomes the Burger Court, which is a much more conservative court. And that's another sort of slice of this story in the book.
And it's fascinating in its own. But we're running out of time, so I want to get to.
We are.
We did some research into what the justices were thinking as they took time to rule the cases. I mean, you dove into their thinking, their papers going on right there.
Yeah.
What were they? What were the justices thinking? What were they saying and communicating with each other as they tried to decide this case, and not in a very timely manner?
Well. Thurgood Marshall's still on the court, which is, of course, another reason why this case is so interesting and so important, right? So Thurgood Marshall, of course, is Mr. Brown versus Board of Education, and Mr. School Desegregation. And he's still on the court, and I think where Thurgood Marshall comes out on this, even if you hadn't read the case, and I'm sure that many of you have. But you've got these new justices, and in particular, you've got Justice Powell, who had been on the Richmond School Board during the Brown resistance period, and then also was a member of the State Board of Education in Virginia. And Justice Powell, who I think is thought of very often as being a moderate, I don't think was particularly moderate when it came to issues of school desegregation. There's some complications there, and I get into them in the book, but the key thing that I found when I looked at the Supreme Court papers was he wrote a very long memo to Chief Justice Berger, who was the one who actually wrote the Milliken decision, an 8 to 10 page memo, and what he's really pushing in this memo hard is the idea of effectively local control, right? And the idea that we have a tradition of sovereignty when it comes to the suburbs and suburban school districts. What's interesting too about the memo is it's light on the law, right? It's not as if this memo goes into great detail about the 10th Amendment or about some other kinds of law that are sort of in tension with the Equal Protection Clause or the Constitution. What it really is like trying to get the Chief Justice to write the opinion in a different kind of way, to make it absolutely 100% clear that there's a kind of sovereignty, a sovereignty halo that is associated with suburban school districts that just is, right? That it has to be clear that you can't include the suburban school districts in any kind of constitutional remedy unless effectively you sue them individually and show that they were individual constitutional violators that created segregation in the city of Detroit, or that you can show that the state itself drew school district lines with an intent to segregate, right? And that's really the memo is really trying to get the Chief Justice away from things that the Justice thinks are important and just focus on the idea of this notion of sovereignty with respect to the suburban school districts. And I think he's
they basically dismissed the whole liability argument. They just kind of set it aside.
Well, set it aside, yeah. The liability argument technically isn't really what they're fighting about, right? I mean, what they're really fighting about is the discrete issue is the remedy out of proportion to the finding of constitutional liability, right? Is this remedy appropriate? We're not going to go back and we're not going to re-argue the liability piece. Yeah, you've got the local school officials. Yeah, you've got the state school officials. But what about that remedy? What about that remedy? Can that remedy go to Royal Oak and Ferndale and Bloomfield Hills, et cetera? And the court says no. The Supreme Court says no. Why?
Can I ask you to read something for me?
Sure.
This is something that Thurgood Marshall said in his dissent. The quote at the bottom.
Our nation, I fear, will be ill-served by this court's refusal to remedy separate and unequal education. For unless our children begin to learn together, there's little hope that our people will ever learn to live together and understand each other.
When I heard the audio, I looked it up and found it.
The oral argument audio.
Yes. And that was an astounding moment for me because it just, in just a few words, he really showed why we are really messing things up here. So this was decided, and I guess what the question is, what does that mean for today? What did the fact that court said, no, we're not going to broaden that out like that. What does that mean to schools in our area as well as across the north?
So I get this question a lot. What is it? I'll give you two answers to the question. The first answer is, what is it meant for today? So I think I mentioned before that there were, maybe I didn't, the Milliken case was an important case, and it was a case that the NAACP put a ton of resources into, but there were other cases like it that were percolating across the North and the West. And the first immediate thing that happens is that the air goes out of those cases because, in effect, what the Supreme Court says in Milliken versus Bradley is that, if the constitutional violation and the constitutional remedy effectively have to be in the same place unless you can make a showing that there's been what I just told you about the suburban school districts or on the part of the state. So it makes it much more difficult to be able to get metropolitan remedies in these cases, and so the cases sort of don't come to fruition in the way they might have if, in fact, the court had gone the other way. So that's the first thing. Is it impossible to have metropolitan desegregation? No, it's not impossible. We actually had it. We had it in Louisville, Kentucky, and I go into some great depth about sort of why that works so well for Louisville, Kentucky. And so, there's that. So then the next piece will become, well, even if Milliken had gone the other way, wouldn't there have been a huge backlash? Of course there would have been a backlash. But I do think that it would have taken us a step further down the line of trying to avoid what Justice Marshall talked about. And we have empirical evidence, quite solid empirical evidence, to show that when children are educated together under conditions of equality from the earliest possible grades, black children have benefited from that in terms of just academic achievement and closing the academic achievement gap, but also all children benefit from that in terms of lessening hostility, lessening prejudice, bringing folks together, and creating the conditions under which I think we need to have a successful multiracial democracy. So that's part of the answer to your question. But then another piece of this is just this question of history, and I think that my book, just in terms of trying to contribute to the history, and of course right now there's so much pushback around sort of what is American history. My book is a piece of American history. It's American history. If you read the Supreme Court case, you would never know that any of the stuff that we just talked about for the past 45 minutes ever occurred. Never. You read the Supreme Court case, first of all, it's I wouldn't say it's confusing, but it's not. It doesn't read the way that Brown is meant for public consumption. Milliken versus Bradley is not. But if you read that case, you wouldn't know anything about the housing evidence. Nothing. It's just not there. It's absent. You would have no idea what the trial was like. You would think that if you read the case, you would think that the trial court judge, who I just described to you a few minutes ago as being conservative, was just a crazed, radical liberal guy. And if you read the case, you would have no idea that what they did in Detroit was to put Northern Jim Crow on trial, right? So part of this is that, it's not just sort of the idea that Milliken made these kinds of cases more difficult in terms of the remedial portion and made it more difficult to sustain metropolitan desegregation. The case itself, as it reads, gives a incorrect view of American history, right? And I think that this question of the importance of American history is incredibly important for us to be able to understand and to be able to move forward together as a nation. And so what I'm trying to do in my book is to allow us to understand what the history is, not to further separate us, but to bring us together and move forward as a nation. And you read the Supreme Court case and you do not get that.
I've been instructed that we are opening this up to you for your questions. If you have a question you'd like to ask Michelle. Kristen, are the mics up here? Is somebody handing out the mics? While she's doing that, you did something that I don't often see in this kind of book, and that is you made these characters alive. And one of the things I wanted you to do is, what happened to Judge Roth?
So when Judge Roth announced the liability determination, which was before the remedy, he did them separately, Judge Roth came under extraordinary pressure in our area. He was hung in effigy, he was called every name in the book, death threats, had to have increased security. And I spoke to one of his clerks, and he had a series of heart attacks, and I spoke to the clerk who worked that term with him, and his clerk told me on the record and then reaffirmed on the record that the pressure of this case and all the litigation around it hastened his death. His clerk also told me that he was glad that Judge Roth died a couple of weeks before the Supreme Court overturned his metropolitan order, and of a third and final heart attack. And his clerk told me that he was happy. He was glad that the judge never saw that.
I'll ask you about somebody else before. We're going to give these folks a chance.
Yeah. Did everybody hear that? Yeah. So
is this mic on? Okay.
Yeah. So that's the answer with respect to Judge Roth.
It's really sad.
Yeah. Oh yeah. Absolutely.
Tell us who you are, please.
Okay. Good morning. Haywood Edwards. I'm from Mitshkun. Pleasure. I'm excited to be here. Looking forward to reading the book.
Thank you.
Okay. So with your book, you talk about desegregation. A lot of communities relatively achieved desegregation, but fell short of integration. So what policies do you think are necessary and relevant today to actually achieve something similar or close to integration as opposed to just desegregation?
My book, thank you for the question. My book is a demand-side intervention. And what I mean by that is that you're asking me a question here, and I'm going to answer it up here, and then I'll also direct you portions of my book that go directly to your question. There are a lot of things we can do to achieve real, true integration. And in fact, I've got a chapter called True Integration, which I think is different than just desegregation. And as an aside, I think there's a guy named John Powell who I think you'd be very interested in reading his work, because he talks a lot about this idea of true integration. But before we can implement any retail policies, we have to actually make the argument to our fellow Americans that this is an important thing to do. And because otherwise this is going to be viewed as taking something from someone. That was what busing was all about. You're taking something from me. I'm losing something. You're telling me how to educate my child. This is going to hurt my child's education. We have to win the argument up here before we can talk about what the specific policies are down there. Now, having said that, one of the things I really like was the Strength and Diversity Act, which I think now has been introduced 5 different times and was recently introduced in the House by Bobby Scott, I think in May of 25. And it really does something that was important and was just starting to happen in southeastern Michigan. Was it basically creates grants to bring members of the community together across jurisdictional lines to talk to each other about, hey, can we think about where we want to draw these district lines? Can we petition whoever is responsible in the state to think about maybe having a regional school district as opposed to a city-based school district? And this is harder in the north than it is in the south because of our municipal government here, we tend to have many, much smaller school districts than they have in the south, which are often county-wide. We have to, I don't need to tell you guys about the notion of needing to change housing policies and to increase the amount of housing, right? So there are a variety of different things we can do, but I think the problem is that we're on the back foot because diversity is a dirty word. Integration, I haven't heard that word since 1974. Somebody's trying to take things from me. All of this kind of thing, I think, is not just bad for students of color, it's bad for the country. And that's one of the things I wanted to do, was to try to write a book for everyone and to pivot and say, this is something that I think we tried, we did not complete that project, but it's best for the country to try to knit us together. So I would say a bunch of stuff in chapter 24 of my book. Strength and Diversity Act, there's a bunch of housing, we can change some of our zoning. Increasing housing, by increasing housing and lowering the cost of housing, it means that if we're going to have neighborhood school rules, it means that more folks can be in areas where they get access to the schools. So there's a bunch of things.
Great question. Is this one on? Okay. And as a reminder, Michelle's book will be in the lobby. Literati Booksellers is here. So if you would like to purchase a book and have her sign it, we can do that.
How you doing? My name is Joanna Underwood,
Nice
and I'm a
meeting you.
housing specialist on behalf of Councilmember Mary Waters. And listening to what your book is about, I'm definitely interested in buying it. But I think
That's great.
I think it was a plan, now that you went over these cases, because in the future, they closed down 100 of those neighborhood schools in the city of Detroit. And when they closed down those schools, they shut down the whole neighborhood. And people do not understand that when you close down schools, we lose housing, we lose whole communities. And my question is that because of this happened back in the 70s, is this the reason why we have like 694 different school districts in the state of Michigan?
So 2 things. Number one, I went back to Clinton Elementary, and you'll see that at the end of the book, and I couldn't find it because it's not there. I think the discrete answer to your question has to do with the difference in local government law between the South and the North. I don't think that I don't think Milliken is why we have so many different school districts. I think the number of school districts preceded Milliken, and it's because of sort of how we sort of arranged our cities and our schools, our cities, right? Because the school districts typically are the same as the city lines versus in the South, and it's just a difference in local government law. But I don't think Milliken is the cause of that. I think that preceded Milliken.
Hi, can you hear?
I sure can.
So,
What's your name?
hi, I'm Kathy Wyatt.
Hi, nice meeting you.
So one of the things that I see is that we still have school districts that are segregated. We have, and here in Washington County, we like to pat ourselves on the back for being so progressive and so liberal. But we have a majority black, majority minority, and school district that is also majority high poverty. And what I see happening in a lot of places is that that's okay, because the narrative is that it's not state action driven, which is constitutional violations, legal, there's laws on the book. But it's not state action, it's economics. The economics, of course, if you read your history, is driven historically by racism and the redlining and all that. But as it gets further and further away from the state action, the argument is all of these things are economics.
Did you have a question for Michelle?
So what I'm asking is, how do you fight that? The Constitution doesn't require equality around economics.
That is correct. And I'll just add a little bit to that, which I'm sure you already know. So my book is about Milliken versus Bradley, but there was a case the year before, in 1973, called San Antonio versus Rodriguez. And that had to do directly with school finance and school funding. And in effect, what the court said there is that there's no fundamental right to an education. And even if a state decides to fund districts radically differently, so that students who are living in districts where their parents' houses are worth less, and they're using that as a tax base to determine how much money is going to go to the schools, and it just doesn't matter. It doesn't violate the federal Constitution. Now, there's been some success with respect to litigating these school finance cases on the state level, and so that is in part what can happen. But one of the reasons why I decided to write this book, and one of the reasons why Milliken versus Bradley is such a tragedy, is that if we were going to make that change, 1974 would have been the time to make it, and for the exact reason that you're talking about, because we were that much closer to sort of the moment when there was verifiable, actual, I can see it Jim Crow. The further and further we get away from that, the harder and harder it is for folks to be able to say, well, the reason why X happened or the reason why Y happened is because of some state action. And what we mean by state action is you can trace it to governmental action. I think that's a really, really hard problem. I think that, again, what we need to do is to continue to push, and that's why I started my conversation by thanking every one of you in this room for the work that you do, right? You are not alone. I've gone across the country and I've talked to a bunch of different groups of people who are deeply committed to this, but a lot of us, we're sort of operating in silos, right? So I see them, you don't see them, but I think what we have to remember is the folks are out there. But litigating under state constitutions, there's a bunch of organizations I mentioned at the end of my book that are working on these issues. And to continue talking in our communities about why socioeconomic integration is so important, right? Because the other piece of it that's been taken away, and I sort of start the book in talking about a case called Parents Involved, which we can talk about offline, is that you can't really use racial classifications and say, well, that's how we're going to be able to choose who's going to go into our schools, right? The Supreme Court has sort of taken that off of the table. But what you can still do is you can seek to achieve socioeconomic integration, and you can use all kinds of different mechanisms that don't expressly talk about race to try to bring students together. But I agree with you, it's difficult, there's no question.
The executive director tells me we have one more question. Time for one more question.
And to that point, that's why Megan's case was so important and why our new state law is going to make an impact for socioeconomic reasons. One last question over here? Okay. Sheila.
Thank you. In the city of Flint,
What's your name?
Sheila.
Hey, Sheila.
Hi. In the city of Flint, there's only one public high school left to serve the entire city. The second to last one closed a couple years ago in favor of high-end condos. And I think I wanted to know, compared to today, where there's a big push for charter schools and developers lobbying the climate of housing and education, did that match what you were seeing when you were writing the story?
I mean, certainly the charter school phenomenon is after this story. But one of the things that is coterminous with it is magnet schools, right? Even at this time, we sort of have the beginning of the magnet school movement around 1965, 1966, and I talk a little bit about that in the book. And magnet schools historically have been quite successful in providing parents really want choice. And I think when we start thinking about how we put these things together, we've got to be able to provide parents with choice. We've got to be able to provide them with high quality education. And we also want to be able to try to provide an opportunity for students to come together, right, and to create the necessary preconditions for democracy. Magnet schools have been quite successful at doing that, and one of the things I talk about towards the end of the book is the idea of there's the Magnet School Assistance Program and adding more money to that, and that just more generally building out magnet schools. But so no, charter schools postdates the stuff I'm talking about in this book.
I'm going to ask you one more question.
Sure.
One more character.
Yeah.
Nathaniel Jones. He was an assistant counsel for the Kerner Commission.
He was.
He was the power behind, the brains behind this case, Bradley versus Milliken. Where did he end up?
He ended up on the Sixth Circuit. He was a general counsel at NAACP up through, 76, 77, and then went on to the Sixth Circuit and then retired. And I spoke to him about a year before he passed.
I spoke to him about a year before that.
Yeah.
In Cincinnati, in his office at the Sixth Circuit. It was a real treat.
Yeah.
He was a great guy.
One of the last things I'll just say about this is it was such an honor for me to have the opportunity to talk to so many folks who now are no longer with us. June Shagaloff and Damon Keith and Nate Jones are the three that really come to mind who, get their moment. And I had a chance to talk with them. And particularly when you take a look at the book, take a look at June Shagaloff, the Johnny Appleseed of Northern DSEG. Fantastic person who invited me into her house and set out a tea set. And then we spent the afternoon together. And then suddenly there's just this box of material that she produces. And it's like original amicus briefs in brown and just like all this incredible material. And it was just a joy, highlight of my life to be able to spend some time with her.
The book is The Containment, Detroit, the Supreme Court, and the Battle for Racial Justice in the North. The author is Michelle Adams.
Thank you, guys.
It was a pleasure to meet you. Can I get you to sign that book?
Oh, yeah, absolutely.